Welcome to Faith and Politics, a show dedicated to discussing issues surrounding the intersection of church, state, and politics, and the examination of whether you're allowing your faith to shape your politics or are your politics starting to shape your faith. In other words, what do you do when God and government come face to face? I'm your host, Orlin Johnson, and let me introduce you to our roundtable of regularly scheduled panelists. First, we have with us Mr. Andre Wang, who's the General Counsel and the Director of Public Affairs and Religious Liberty for the North Pacific Union Conference of the Seventh-day Adventist Church. We have also Ms. Nia Johnson, who's a visiting assistant professor at Duke Law School and a health policy PhD candidate at Harvard. We have Joe St. George, who's with us, who's the Chief Legal Officer for the Women of Color for Equal Justice Law. And we have Mr. Lawrence Parrish, who's a former senior counsel with the United States Securities and Exchange Commission. Ladies and gentlemen, thank you so much for being with us today. And why don't we go ahead and start with our first segment. Segment one is talking about a topic that we found a lot of information going along during the pandemic. It was an issue regarding whether or not people should get vaccinated or not get vaccinated. And OSHA regulations were put in place that seemed to be focused on issues as it related to healthcare safety, but somehow it still pulled in the idea that somehow if you were vaccinated, that maybe that was the component that needed to be done as part of OSHA. Supreme Court came in and made some modifications, but Joe, could you tell us a little bit through that concept of, is it Title VII? Is it OSHA? Who really should have had control of this?
Well, the control is dictated by how the legislature creates a mandate or a requirement focused on a particular group. So if a legislator legislates to only govern workplace safety, then it's OSHA. If there is a regulation that affects all community people in whatever range that the legislation applies to, then OSHA can still apply. It's just depending upon what is the workplace safety method. And in this situation, in New York in particular, the city of New York mandated vaccines for all its employees and private employers. Anything that touches or concerns the workplace will always be governed by OSHA unless the state or the employer seeks a variance, an exemption for trying to regulate in a space that's already regulated by OSHA.
So let me ask you this question, Andre. So if OSHA is on one hand looking at the workplace and you got the vaccines that's talking about health and safety, did it turn out that it got a little mixed up and the Supreme Court had to come in and untangle this? Or am I missing something here? Help me understand what Joe is trying to combine and make clear for all of us.
Yeah, so as Joe's laying out, the OSHA authority came out as temporary, as an ETS, emergency temporary standard, and so when that was declared in November 2021, it came out as this is the scope of the mandate, and by the way, it was characterized as a vax mandate, but actually the mandate was a vax or test requirement for employers over 100. So we had employers really dealing with this on two fronts. Number one was the philosophical front, that this was just so fundamentally intrusive by the government. They can't do this, and what can we do to stop it? I had some CEOs and HR managers thinking that this could just go away with the call to a constituent rep to their congressional district office and make it go away. And I had to tell them, no, this is deeper than that. But the second front was logistics. That this was such a big Herculean requirement for them to draft compliance policies and craft vaccination checklists, to audit their workforce and roster templates, and setting up workplace testing procedures for those that weren't vaccinated. And so you had this $14,500 per violation fine that was this Godzilla looming over all of the employers.
Mr. Parrish, you were actually somebody who was a federal employee dealing with this particular issue. When the vax mandate was coming down as it related to OSHA, from a legal perspective, what were you thinking and what was your office thinking?
Well, obviously, our concern about the safety and welfare of those who had coming into office. I tend to lean more to thinking OSHA should have had some dealings with it, and it may have lied or should have lied under their purview. When you look at OSHA, their concern is that whether or not the employees are safe. I know the issue of COVID, even though, some may argue, well, should you mandate that they have to be vaccinated? The issue had to deal with their colleagues who had to still share the same office space and things of that nature. So the level of comfort that myself and others may have had when coming to the office, knowing that our colleagues were vaccinated, did give us a level of comfort.
But Nia, let me ask you this. The Title VII aspect of this wants to make sure that people understand that if it pertains to race or religion or things of that nature, the government should not be intertwining. And we had people who didn't want to get vaccinated for religious reasons. How do you kind of juxtapose those two things, and which one maybe should have taken more precedent?
Well, I think I used to have a law professor who would always say it's important that the law is decided well and right the first time, because you ring in all of these different implications when you're thinking about these issues. But I do think that this is always going to be a sensitive issue for the court to deal with. I mean, we like to say that this court doesn't have a stance that's, neutral politically, but, there are different concerns and values that are brought into these type of decisions. And I think when we think about the health and safety of different individuals in our communities, right, when we think of the health and safety of individuals who are immunocompromised, who are disabled, who are part of marginalized communities that have experienced, greater complications with COVID-19 due to the impacts of systemic racism and promoting different health disparities and what have you. There are legitimate concerns on both sides. And so this is going to be a balancing act, and this will really be an issue of deciding, which legal pathway ultimately creates the best outcome for the most people, but also doesn't forget other individuals that could have different challenges.
Well, Joe, do you think the confusion was primarily because the COVID situation was new, they didn't quite understand? Eventually we realized even if you're vaccinated, you could still actually put it forward and give it to somebody else, and maybe that's why they ended up going down that route? Please go ahead, Joe.
Yeah, I want to make two things clear, because there has been an inappropriate narrative that has been put into the public sphere, predominantly by our media outlets, that the vaccine is a safety method that is approved by OSHA. And it's not. Vaccines are medical treatments that only affect the immune system, which everyone argued about its safety. But OSHA is the sole authority in the United States that can authorize and approve what methods are used to keep employees safe. And vaccines have never, in the history of OSHA, since they've been in existence since 1970, has been an approved method specifically for communicable diseases that are airborne. There's respiratory standards that specifically require the method to be able to do two things, or one of two things. One, either remove an airborne hazard from the air, or the method has to provide a shield to protect the individual from exposure to the airborne hazard in the air. And because COVID is transmitted in the air through droplets of people talking and spitting or whatever, it is an airborne hazard, was always defined that way by the CDC and Fauci himself. And so therefore, vaccines can never be an approved method that the Secretary of OSHA could ever approve, because functionally it does nothing to make the environment safe. The red herring in the room has been the argument regarding its efficacy as it relates to the immunoresponse. Those are two separate issues, right? And employers have no right to dictate an individual's choice of medical treatment. The Supreme Court has made clear that each individual has the right to choose their medical treatment, even to the extent that they choose to abstain from medical treatment and it results in their death. And that's the history around euthanasia, or a person saying that they have the right to die, to refuse medication, or to take on the risk of medications that haven't truly been tested. And all of this is really born out of the President Trump's approval of allowing people to use test medications that haven't been proved approved by the FDA, the Federal Drug Administration.
And
And
Joe, I'm going to have to let that be the last word on this, but I think what we're
Sure.
seeing is the balancing test between Title VII and how we would go about OSHA. And the point being raised that OSHA in its history had never really reached into issues from a healthcare perspective as relates to safety is something I think that's important for us to think about. And it's a battle we'll probably see going down the road.
Well, actually, let me clarify that.
Well, Joe,
because-
let's go on to the next segment and we'll do some clarification on that a little bit later. So segment two, we're moving into the idea regarding the SEC's Office of Investor Education. They engaged in an advocacy and a retail strategy where they were putting together a task force. One of the things that shocked me is I got a call from the Securities and Exchange Commission saying, we've got a problem where we're seeing that fraudulent and bad actors are actually targeting those individuals who are members of churches. They are going in and saying that this is a group of individuals that seem to be more apt to listening to potential pitches on financial activities and sometimes even hearing it at church where their pastors have allowed people to come in. Mr. Parrish, you've seen this activity, and I've been noticing that there have been individuals who've been bilked out of millions of dollars simply because they were part of a church organization. And as a former member of the SEC, what was the work that you guys had to do to figure out how to manage that?
Orland, I apologize. Let me first say that I was employed at the SEC for over 28 years. And in that capacity, I was an enforcement lawyer. And I was tasked with prosecuting individuals who basically defrauded investors of their hard-earned funds. As it relates to churches, we consider it affinity fraud. Affinity fraud is when individuals target a certain group of individuals, be it race, a gender, association with an organization, and as you were indicating, as we're speaking about churches, has been a big target of these fraudsters. What the SEC has tried to do is reach out to religious organizations and try to provide them with information to safeguard their parishioners. This is something that, from time to time you run against the question of whether or not the SEC should be involved with church and religious institutions, but the SEC has a task of safeguarding all investors, regardless if you're a member of particular organizations, fraternity, again, church, or that matter. You find that churches are an easy target because Christians tend to be trusting individuals. These fraudsters tend to target these individuals because they prey upon them. They'll quote scripture that, that good Christians should give, and they take advantage of, again, like I said, the trusting nature of Christians. What we try to advocate during that time is that investors, regardless if you're a member of a church or any organization, that you should ask a number of questions. You should determine if this person has a background that has any type of criminal conduct that has been perpetrated by this person. You need to reach out to your lawyers or other professionals, and it doesn't have to be a professional per se, but ask questions about this person who's targeting you to invest. If they're trying to prompt you to invest quickly in telling you things such as you're going to miss out on this opportunity, that's a good sign that you need to slow your roll and take some time to do some due diligence to find out as much as you can about the product that they're trying to encourage you to invest in.
Well, Joe, let me ask you this question. If now we're starting to see individuals who are fraudsters that are focusing on church members, and so happens maybe the pastor invited somebody to come in and speak, what do you think the role of the pastor should be in this type of situation?
It is one in which the pastor has a duty to his congregants. And that duty is to uphold their religious belief system. And recognizing his obligation, however they define it, they would be in a very precarious situation, finding themselves endorsing a particular individual or any individual in their congregation when it comes to making financial investments, because then they could be part of the conspiracy to commit fraud if fraud is found against the individual who does make representations to the church members.
But let me ask Andre a question. Andre, if it looks like a pastor has brought somebody in and we find out he had no idea this individual was involved in something fraudulent, he just thought it was something be interesting that maybe he was involved in and wanted his members to be involved in, and now the SEC feels the need that it needs to start talking to church leadership, what exactly should we be starting to tell our pastors? Or should they be under a different level of scrutiny? Or should the mens rea actually come into play, or the intent to engage in wrongdoing?
Yeah, I think that this is a kind of a perfect bar exam question of does the pastor have a duty of care? A pastor is there to be a minister, to shepherd to their flock, to their congregants. Are we going to put the burden on them to also be a kind of a screener or a scrutinizer of business dealings that are coming into the church? Predatory behavior is in every facet of human life, and securities is no different. Predators prey on the vulnerable, and whether the vulnerable are the elderly or an ethnic group or whatever disenfranchised class, the one characteristic they all have in common is this naivete of desperation, that in the end they'll get something better. So if the pastor knows or has reason to know that there's this activity going on in the church, then yeah, I do think that the pastor does have a duty to step in and protect the congregation.
Nia, I'm going to give you the last word on this, as we're starting to see that we have multi-levels, so you can come at church and come as seniors. What's your thought process on who should be held responsible for this?
Well, I think it's really important to remember that church spaces have always been very fluid places. They have been places where people have, seeked counseling, even though, there haven't necessarily been certification for counseling in church spaces always. It's been a hub for community engagement. It's been a place for organizing and voter registration. And so I think due to the fluid nature of church, we do have to ask, is there a heightened responsibility for church administrators and pastors to start treating their churches more like the fluid spaces that they are? And there, and I think there's also a really important point to be brought up about even a conflict of interest as a pastor. If you're interested in an investment, you have to be cautious when you're thinking about promoting that investment to your congregation. And as much as we've said in this setting that, the main job of a pastor is to shepherd, right, we know that historically that has not been the job of pastors. It's been much broader than that. And so that may require a broader mens rea requirement and obligation of duty of care for pastors in these situations.
Wow, I'm gonna have to let that be the last word, but boy, we're starting to see that we've got churches have got to be protected from fraudsters. I mean, where are we going in this world? Well, let's go on to segment 3. Segment 3 talks about a case that's called Ramirez versus Collier. This is really a very interesting case as it relates to death row. In Texas, we had somebody there who was on death row, and there were some issues regarding how he wanted his life to end as it related to his religious convictions. Andre, can you tell us a little bit about this case and what really caused the Supreme Court to have to get involved here?
Sure. So we have an inmate in Texas on death row, and as part of his execution, he requested that his pastor be present in the chamber, praying and laying on of hands as he was dying. The Department of Corrections in Texas denied his request, and so this made its way up through the courts. The inmate was alleging a violation of RLUIPA, the Religious Land Use and Institutionalized Persons Act, and the Supremes sided with the inmate, with this Mr. Ramirez. Roberts authored the opinion, and he said that the prison has to show a policy that places a substantial burden on a sincerely held religious belief. So a classic strict scrutiny analysis. I think the Supremes got this right. Roberts looked at this in the totality of the circumstances, in that the prayer and laying on of the hands are traditional forms of religious exercise, and that there's also a history of clerical prayer during the time of a prisoner's execution. So the state's compelling interest argument that that we have to maintain security and sterility in the execution chamber. Robert said there are other ways to address those concerns, such as laying on the hands on the inmate's leg, for instance. So I think Thomas was the lone dissenter in that, by the way, and his rationale was that this was just merely a delay tactic by Mr. Ramirez.
Nia, I got to ask you this question, though. If you're a prisoner and you're actually a ward of the state, there's some people who will say, why do you have to get involved in allowing individuals who are on death row, who are wards of the state, to even be in a position to be protected along those lines? And also the question of sincerity. How do we know that there is a sincerity test that actually was passed for this case? I mean, from your thought process, what were we working with here?
Well, I mean, let's start with what prisons have functioned as in the past. Prisons have functioned as religious spaces and having congregations and having churches, encouraging pastors and, many churches to have prison ministries. And so the idea of somebody even developing a religious conviction in a space like a prison should not be uncommon and unexpected, especially when we talk about something as serious as dying. And I think some of what the flavor of this opinion even brings forward, and I do believe that the courts decided correctly, but even when we think about the circumstances around this, is that prisoners are not treated as meaningful individuals in society. And the fact that they would want to have some level of comfort as they are, going through the death row process seems like something that's such an egregious burden. And I would also like to add that as much as we're talking about sterility and the safety of prisons, lest we forget that not only do prisoners experience some of the worst healthcare in this country, even though they are the only population entitled to a healthcare right as being wards of the state, that COVID was also rampant in prisons due to the inability and the unwillingness of inmates and many state actors to protect prisoners from COVID spread. And so this idea of sterility at this stage versus the entire stage of the pandemic is a little bit perplexing given what we already know.
Joe, what's your thoughts on this? I mean, there's some people that say if you're a prisoner, you're on your own and whatever happens, happens. And what about the idea that maybe the blessing could have taken place without actually being in the room and laying hands?
Well, I think this was a definite pretext for supremacy against a Hispanic person who had every right to exercise his religious liberty. And I don't think we needed to get to RULOPA. I think we need to stick with the reality that the government interest was for him to be executed. When we look at that interest, everything that happens before or even after is almost irrelevant. And so to make a pretextual argument that there was a safety issue, I agree with Nia that, it was bogus. And we should have never spent any taxpayer money on this type of lawsuit when the individuals within the prison system had authority to allow for something in the last hours of someone's life to achieve the comfort that they needed to face the consequences of the choices that they previously made. It was ridiculous. And I have a brother 22 years in prison for being wrongly accused, and they are the most filthy, disrespectful facilities to the human rights of individuals. And I'm fighting constantly with that California prison and other prison systems here in Maryland with regards to proper food and healthcare. So it was pretext, and the Supreme Court should have slapped them down with greater authority on the fact that First Amendment rights are to be protected, and we don't need this balancing routine, particularly in this situation.
Mr. Parrish, I got to ask you this, though. They talk about sincerity. Suppose it turns out that this individual was not sincere. Does that really come into play at all? Or do we simply say this is a dying man and this is what he's asking for? We don't have any time to get involved in the sincerity test.
Well, the court addressed that issue, and I really don't think the sincerity really had any weight on it, regardless of if he was sincere or not. He still had certain liberties and rights that should be, considered. One of the things that I did find interesting in the court's decision was I thought the court definitely had it right. You saw it by the decision 8-1. The only dissent, as was previously indicated, was of Judge Thomas. But I wonder if the compelling issue would have changed as it related to the safety issue that the state was arguing, if instead of the defendant being executed by injection, if it would have made a difference if he was being electrocuted like in the past when they would, use terminate individuals by, execution by electric. Whether or not there would have been an argument being that the pastor was in, and the risk of him being shocked or injured, whether or not that would have had any impact on the ruling. But I do think the ruling was decided right.
Well, I have to make that the last word on this, but it's a good point to mention that this was lethal injection. If it turned out it was something else, maybe things would have been a little bit different. But it sounds like a person who's on their last stage of life should be allowed to have something to happen as it relates to their religious activities. Let's get into our final aspects of our show for today. And I just want to start off with something that you guys can tell me that I don't know. So, Andre, tell me something I don't know.
After the Democrats hold Congress after the midterm election in 2022, because the Democrats will be empowered and emboldened by the Dobbs decision, President Biden will announce that he will not be running for re-election.
Wow. Nia, tell me something I don't know.
Well, it looks like everybody's talking about midterms today, but something that I think a lot of people don't know is that President Biden's approval rating is at 42%, which is pretty standard with most presidents at this stage. Gallup just published a poll on that today. And it's important that we remember that, in the midst of COVID and a number of other narratives about student loan forgiveness, that maybe President Biden and Vice President Harris are ineffectual, it seems like most of the country actually thinks that they're doing well.
Joe, tell me something I don't know.
Well, I have to respond back to the issue of Title VII and applying to OSHA. People don't know Title VII does not apply to OSHA. So if there's any OSHA regulation, Title VII has absolutely nothing to do with workplace safety.
And Larry, tell me something I don't know.
Well, if you're a church parishioner or just any investor, that the SEC offers a website, which is sec.gov, and they have a portal where you can look up your investors, your agents, and your representatives to see if they have a prior disciplinary record, as well as FINRA has a website which is called Broker Check, and you can also do the same there with your representatives.
Well, great. Well, listen, thank you for the conversation that we've had today. I think it's been extremely informative. And I want to thank our audience again for being with us and hope you enjoy what we talked about today. But just remember, if it's about God and government, it's faith and politics. See you next time.